In a medical malpractice case during opening arguments, if there are some details of your case that are extremely embarrassing, can I ask the judge for permission to lock the courtroom door to prevent people from coming in to hear the embarrassing details of your case? Would you like to learn the answer? Come join me on this walk as I share with you exactly the answer. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, I'm walking here in an area of St. Martin on the French side that happened to have been devastated, totally destroyed. You can see behind me how horribly devastated this area was from Hurricane Irma about 11 months ago. And now I have a few moments to share this great information with you. All right, so now let's say there are embarrassing things about your particular details of your case. Can I ask the judge to go ahead and lock the courtroom door? The answer is I can go ahead and ask, but I know the answer. The answer will be no. Why? Because this is a public proceeding. Any civil lawsuit that's brought in New York is open to the public, which means that when you get into trial, anybody can come in and sit in and listen. They can come and go as they please. The fact that you have embarrassing details, maybe about your sex life, maybe about your performance, maybe something that's totally embarrassing, maybe it's financial, maybe it's emotional or relationship-based. The key is you feel embarrassed about those details and you don't want anybody else to hear them or to learn about them. The fact is that your proceeding is public. Now, anybody can go and sit in the courtroom and observe, even members of the press, if they wanted to. The likelihood of that happening is going to be extremely small, but the reality is that yes, anybody can go ahead and listen in. There is no compelling reason why the judge would close off the courtroom to the public because of your embarrassing details. And your attorney is going to tell you, listen, if you can't handle those details being exposed to the public, then you should not be bringing that part of the claim. If it involves your emotional relationship or your physical relationship with your spouse or significant other, and you don't want anybody to hear that, guess what? If you don't include that as part of your claim, then nobody is ever going to talk about that. It's a personal choice. And if you and your significant other or your spouse turn around and bring a claim for emotional distress or physical problems because of what was done wrong, and now you don't want anybody to hear it, the judge may be apologetic and say, listen, I'm so sorry to hear that, but I'm not closing the courtroom door. The interests of public access far outweigh your ability to be embarrassed for a short period of time. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into how these types of cases work in New York. You know, I do realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.